It's time to restore accountability for civil rights abuses. For nearly 80 years, a single Supreme Court decision has stood in the way of justice for victims of official abuse, blocking the executive from stepping in. It's time for that to change. Federal law makes it a crime for anyone acting under color of law to willfully deprive another person of their constitutional rights. Codified as 18 U.S.C. Section 242, the statute was born of Reconstruction and intended to confront the grim reality of state and local officials, sheriffs, judges, jailers, who used the machinery of government to suppress Black Americans and political dissenters. Congress gave the executive a criminal tool to intervene where local authorities refused to hold their own accountable. But that tool is now blunted, undermined not by Congress, but by the Supreme Court. In its 1945 decision Screws v. United States, the court reinterpreted Section 242 in a way Congress never intended. It ruled that to convict a public official under the statute, prosecutors must prove not just that the official acted intentionally, but that they specifically intended to violate a constitutional right they knew was protected under federal law. In other words, the government must prove what was in the official's mind at the exact moment of the abuse, not just what they did. This elevated the bar for accountability so high that, in practice, it's rarely met. Officials can engage in brutal, even deadly, misconduct and still escape prosecution if the government can't prove they were thinking about the Constitution when they acted. In effect, the law protects not the public but the private psychology of the abuser. That's not how Section 242 was written. It's not what Congress intended, and it's not what the Constitution demands. Before Screws, the statute required three things: that a person acting under government authority intentionally acted against someone else, and that this act resulted in the denial of a federally protected right. That standard was strict but fair. It criminalized purposeful misuse of state power that caused real harm to rights. Not mere negligence, not bad policy, but targeted oppression. After Screws, the statute requires prosecutors to show something far more difficult: that the official not only acted willfully, but also with specific legal knowledge and the conscious purpose of violating a right. This turns criminal enforcement into a psychological investigation. It doesn't matter how egregious the conduct was. If prosecutors can't prove the defendant's precise legal state of mind, the case fails. This isn't how criminal law usually works. In almost no other context must prosecutors prove that the accused had accurate legal knowledge. We don't require tax evaders to be experts in the tax code. We don't let corrupt officials off the hook because they didn't understand the ethics laws. But under Screws, a police officer who kneels on a person's neck, a jailer who retaliates against an inmate, or a judge who imposes disparate punishments may all escape prosecution. Not because they acted lawfully, but because it's just too hard to prove what they believed about federal law at the time. This standard is not just doctrinally flawed, it is constitutionally corrosive. It guts one of the few criminal statutes designed to protect the public from government actors who use their position as a weapon. It also undermines the executive branch's ability to enforce the law effectively. The Department of Justice can't credibly pursue civil rights enforcement through plea deals, reform agreements, or direct prosecution if it cannot back those efforts with a plausible threat of criminal accountability. The court claimed in Screws that it was concerned about vagueness, that criminal laws must give fair notice. But instead of refining the statute's terms or asking Congress for clarity, the court imposed a new mental element that makes the law nearly unenforceable. It didn't solve the notice problem, it replaced it with an accountability vacuum. And there's no good reason to retain that mistake. No one relies on Screws to structure their conduct. The original statute is clear in its text and purpose. The evidentiary standard it established, proof of state authority, willful conduct, and actual rights deprivation, was already exacting. It didn't criminalize bad decisions. It criminalized the deliberate use of government power to suppress federally guaranteed rights. The case for overruling Screws meets every test the Supreme Court uses when revisiting precedent. As the court emphasized in Dobbs, Janus, and Kimball, A precedent should fall when it is egregiously wrong, unworkable in practice, unsupported by textual or historical foundations, and unmoored from legitimate reliance interests. Screws fails on all four counts. This is not a call to expand federal power. It is a call to restore it, to return Section 242 to its original design as a constitutional backstop against state-sponsored abuse. The statute was meant to be used carefully but clearly, to ensure that no official, no matter how powerful, can act with impunity. In a time when public trust in institutions is fragile, and when abuses of authority continue to disproportionately harm the most vulnerable, it is more important than ever that our legal system make one thing unmistakably clear. No one is above the Constitution, not even in uniform, not even under color of law. Overrule screws. Restore Section 242. Reaffirm the President's promise of justice.